So Anthony, do you want to go ahead and start and take it away?
Absolutely. Let me adjust my camera. So, hi everyone. I would like to thank our panelists very kindly for taking the time to touch on this significant event, and of course, Dean Farnsworth. We appreciate that. My name is Anthony Collier. I'm the SBA president at the University of Texas School of Law, but I also have the privilege of serving as chair of the Southwest region of the National Black Law Students Association, also known as SWABASA. And SWABASA consists of Texas, Arkansas, Oklahoma, and Louisiana, and we represent 19 ABA accredited law schools. The National Black Law Students Association is the largest student-run 501c3 in the nation, and I'm honored to be a part of such a historic organization. It was founded in 1969 at NYU, and so we represent the interests of Black law students across the nation. And we also have an organization in Canada as well. And so we're honored to be a part of this critical discussion.
Again, just thank you, Dean Farnsworth, Somil, and Clark for being here. My name is Medushi. I am representing the American Constitution Society chapter here at the University of Texas. For those of you who are unfamiliar with us, ACS is a progressive legal organization, and our goal is to kind of discuss ideas under the umbrella of kind of progressive law and kind of viewing the Constitution not just based on its text, but also against history, lived experience, and kind of making sure that the law can uphold all people and to promote justice and improve people's lives. So that's a little bit about kind of our organization.
Hi guys, my name is Seth Smitherman. I am the president of the Texas Federalist Society for this year, and just a little bit about us. We are a group of largely conservative and libertarian, but also moderate and centrist students at the law school committed to the idea of judicial originalism. And despite our differences with ACS, we can definitely come together on this issue, which is pretty cool. So without further ado, I'm going to take us over to our dean of the law school, Dean Ward Farnsworth. We're really glad that he's here tonight to introduce the speakers. So Dean, the floor is yours.
All right. Thank you, Seth. It's my pleasure to be here with you. And I just want to start by thanking Anthony, Medushi, and Seth for your leadership and thanking your groups on a couple of counts. One is that in these times with the public health crisis and all that comes with it, it takes more effort than ever to keep the intellectual life of the law school alive with events like this. These kinds of conversations are a very important part of law school. It's not just what happens in the classroom, it's what you hear during your lunch break. But right now, we can't have talks during our lunch break. So I'm so pleased that we can have an event like this. And beyond that, I'm just so grateful because right now, of course, our legal culture and the rest of our culture is so polarized. It's very hard for people who don't agree about basic things to get together and talk, cooperate. And so to see the American Constitution Society, the Southwest Black Law Students Association, and the Federalist Society all get together really warms your dean's heart, because I know you may not agree on a lot of fundamental issues, but what I do know you agree on is the importance to our community of having high-level discourse about matters this important. So here's to all of you, and thank you so much for putting on this great presentation in bringing us these two wonderful panelists, to whom I now turn. We have a couple of great Texans who are originally from rival high schools in the Dallas area, coming back now to talk about these extremely interesting legal questions. Clark Neily is Vice President for Criminal Justice at the CATO Institute. His areas of interest include constitutional law, overcriminalization, coercive plea bargaining, and police accountability. Before joining CATO in 2017, Clark was Senior Attorney and Constitutional Litigator at the Institute for Justice and Director of the Institute's Center for Judicial Engagement. He's an adjunct professor at George Mason's Antonin Scalia School of Law, where he teaches constitutional litigation and public interest law. Clark served as co-counsel in the District of Columbia against Heller, in which the Supreme Court held that the Second Amendment protects an individual right to own a gun. He received a Bachelor of Arts in Plan 2 with concentrations in philosophy and Russian from the University of Texas at Austin. And he also received his law degree right here from the University of Texas, where he was chief articles editor of the Texas Law Review. He's the author of Terms of Engagement, How Our Court Should Enforce the Constitution's Promise of Limited Government, and the author of, as well of a lot of great writing online that I commend to you. When I was thinking and talking with a lot of people over the summer about the turmoil after the killing of George Floyd, I referred many of them to a piece that Clark wrote called America's Criminal Justice System is Rotten to the Core, which made a lot of very important points that are very underappreciated. Clark, we're very proud of you and proud to be able to call you our own. Very grateful always to have you back.
Thanks so much, Dean.
Our other panelist is Somil Trivedi, who's a senior staff attorney at the ACLU's Criminal Law Reform Project in Washington, D.C. He focuses on prosecutor, police, and jail reform and is counsel for the ACLU in several qualified immunity cases and amicus briefs, many of them with Clark Neily at CATO. And I know he and Clark both teach together at the Scalia Law School. Somil was previously a prosecutor himself at the Department of Justice's Criminal Fraud Section and the U.S. Attorney's Office in Washington, D.C., as well as a white-collar criminal defense attorney at WilmerHale in New York. He graduated from Georgetown University, from the outstanding Boston University School of Law, and most importantly from Pierce High School in Dallas, Texas. Let's welcome our two wonderful panelists. I'm so looking forward to hearing what you have to say. Thank you.
Cool. As I alluded to in the webinar chat, we're going to format tonight as a question and answer style. So I'm going to go ahead and open us up with the first question, very simple. For the benefit of the uninitiated, would one or both of you briefly describe the basics of Section 1983 liability and qualified immunity? Where did it come from?
Well, Somil very graciously deferred to me as an alum. Certainly not necessary, but somebody had to go first, and so I'll sort of dive right in. When you clothe government officials with the enormous discretion and authority that we do in this country, this includes the authority to stop you against your will, to hold you, to arrest you, to prosecute you, and ultimately to incarcerate you or even to take your life. It is extraordinarily important what kind of accountability comes with that. Because after all, government officials, like the rest of us, are human. They are therefore fallible, and they will occasionally, and sometimes more than occasionally, abuse the authority that is conferred upon them by us. And that's important to keep in mind. We confer that authority upon them, and we, as citizens of a democratic republic, have the ability to determine the amount of accountability that comes with that discretion, that authority that we confer upon them. In 1871, in the wake of the Civil War, and the beginning of what would ultimately become America's apartheid system of Jim Crow, Congress actually managed to get something right, which is an odd thing for me to find myself saying as a libertarian, but they did. And what they did was they enacted what we now refer to as Section 1983, because that's where it is in the U.S. Code, 42 U.S.C. Section 1983. And both the purpose and the function of Section 1983 are perfectly clear. And I'm just going to quote for you the operative language, because it is the language of Section 1983 that makes so clear why it was enacted and what it was meant to do in our system. Section 1983 provides that any state actor, that means anybody employed by a state or municipal government, shall be liable to the person injured for the deprivation of any right. Let me say it again, because it's extraordinarily important in this context. State actor shall be liable to the party injured for the deprivation of any right. Now, for a number of reasons we'll get into later, Section 1983 was not sort of a key aspect of sort of Reconstruction era civil rights litigation, in part because it was only well into the 20th century when the Supreme Court began recognizing that provisions of the Bill of Rights were enforceable against state governments, and therefore, if you were, for example, denied due process or censored or deprived of equal protection by a state or local government, that you might actually have a cause of action. Again, we may revisit that, but the basic point is this. Right around the time that the Supreme Court began to get serious about ensuring that the federal government and the federal constitution would be applicable as against state and local actors. In other words, that you could go into federal court and make a claim that that your constitutional rights under the Bill of Rights and other provisions have been violated. Right around that time is when the Supreme Court invented out of whole cloth what we now know as the doctrine of qualified immunity. The first step was in a 1967 case called Pearson v. Ray. It was a very limited step where they essentially granted immunity to some local police officers for enforcing a law that was later determined to be unconstitutional. And the court found, well, you know, these guys were acting in good faith. They didn't know the law would ultimately be found to be unconstitutional. Let's give them a break. The doctrine of qualified immunity then sort of metamorphosized into what we now know it as today, which is this, really, I call it a kind of a get out of accountability free doctrine that the Supreme Court has invented out of whole cloth. And that big step came in a 1982 case called Harlow v. Fitzgerald, where the Supreme Court took a really big step forward. And I'm going to just really take 30 seconds to paint with a broad brush, and then we can come back and fill in the details. But here's what the Supreme Court did in Harlow. It judicially amended the text of Section 1983 by inserting two words that do not exist in the actual congressionally enacted statute. And what the Supreme Court said was that under Section 1983, you can only sue a government official for the violation of a, quote, clearly established constitutional right. Again, those two words, clearly established, do not appear in the statute. The Supreme Court effectively inserted them, and they do a tremendous amount of work. And the basic role that they play in civil rights litigation today, those two words, clearly established, is that they make it impossible to sue a police officer or other government official unless there happens to be a case in the relevant jurisdiction where a government official has done essentially the identical same thing to somebody else, and the judiciary has already stepped in and said, you can't do that. That's unconstitutional. That's not permissible. If you cannot find a case with functionally identical facts, even if everybody agrees that your rights are violated, and this happens, even if all of the judges who look at the case say, yep, that's a constitutional violation, the mere absence of a pre-existing case means that the right you are trying to vindicate in that particular factual context will not be clearly established, and your case will be dismissed on qualified immunity grounds. You will not receive any relief for your claim, and more importantly, or maybe I should say equally importantly, the government official, oftentimes a police officer, will almost without exception therefore get off scot-free for that constitutional violation. So to summarize, qualified immunity is a doctrine that comes into play when the government has violated somebody's rights, and it functions as a kind of free pass doctrine that the Supreme Court has invented out of whole cloth in direct contravention of the language actually chosen by the Congress.
And I'll just chime in to say first, thank you to ACS, to FedSoc, to Swabalsa for having us. Secondly, Clark nailed it. Third, I would just emphasize the history of Section 1983, which was originally called the Ku Klux Klan Act. And get this, it was implemented because members of the KKK and other white folk after the Civil War were terrorizing newly freed Black people, and law enforcement was simply not doing enough about it. The not doing enough about it was enough for Congress to act and pass Section 1983. Imagine what that Congress would have thought about the situation we have today, where not only are police and prosecutors not charging folks for violating Black people's rights, they are the ones violating the rights. So we, if anything, and not to exaggerate the point too much, but if anything, we are in a more dire situation today than we were at the passage of Section 1983, which makes qualified immunity even more abhorrent, to us at least.
So I think both Clark and Somil kind of alluded to my next question, which is what makes this doctrine problematic as it is to people with varying kind of philosophies on constitutional interpretation and politics. So I know that we kind of alluded to it a little bit before, but if there's anything else that either of you think is critical for our audience to keep in mind as we're kind of continuing this conversation, yeah, that would be great.
Yeah, I think to echo Dean Farnsworth's words about the fact that disparate political philosophies or seemingly disparate political philosophies can converge on this and many other issues. Qualified immunity is problematic for a number of reasons, some of which sort of hit home more closely for certain people, and some of which hit home more closely for others. Clark very well elucidated the fact that if you care about textual interpretation of statutes, then qualified immunity is an abomination because it just don't exist in Section 1983. That's a simple enough reason not to like it. What Clark hinted at, and what folks at the ACLU might emphasize, is that even if you believe that the text of statutes and the text of the Constitution can evolve over time, as Minushi, you pointed out in the ACS's mission, we believe that the purpose of the Constitution is to enshrine the values that underlay the Constitution and statutes like 1983. And we can see that qualified immunity has become a shield for often racially disparate treatment of marginalized communities in the United States. And for that reason, you can also become enervated about Section 1983. But I don't want to belabor the differences between these because they are ultimately the same. The point is, we had, as Clark said, a prescient Congress who realized that we needed federal intervention to protect newly freed Black people, and we still need that today. And so why the Supreme Court felt in 1982 we no longer needed that is a mystery to me and to Clark and folks all across the ideological spectrum, I think.
I would just add one thing, sort of a practice pointer here for my friends from Texas. If you're going to be litigating in the Fifth Circuit and you have an opportunity to quote John Marshall, you should take it. If it's Marbury versus Madison, you should actually pound the podium at the same time. John Marshall, Chief Justice Marshall, in Marbury versus Madison said that a government cannot be called a government of laws and not of men if the laws furnish no remedy for the violation of a vested right. And that is the key function of qualified immunity in our system, is precisely to deny a remedy for the violation of vested rights. It is impossible to imagine a doctrine that is more contradictory and that more flies in the face of that observation of Chief Justice Marshall than this qualified immunity doctrine that, again, the Supreme Court invented out of whole cloth in an act of actual judicial activism. I got a whole thing about judicial activism. It's way overblown, but this actually was an example of judicial activism. This is legislating from the bench. And for reasons we can get into later, it has been an absolute disaster, both for individuals and for society. And interestingly, I think Somil and I both believe also for the law enforcement community, by infantilizing them and treating them as if essentially it's just impossible to expect them to honor the Constitution and respect people's rights. So it's just been a disaster across the board.
Cool. Okay. So moving on, I would like to just touch on, basically just try to dig in a little bit and see where y'all think what bad is doing the work exactly in qualified immunity. So in a world where we repeal qualified immunity, either by legislative mandate or the Supreme Court actually, gets its act together and decides on a textual interpretation of the statute, does either of the two important prongs of qualified immunity analysis survive in both of y'all's ideal versions? So just for context, that's the reasonableness prong and the clearly established prong. I think we've already gotten the answer to the clearly established prong, but an open question: what does your doctrine of police protection look like?
Clark?
Yeah, I'm going to go short and then hand it off to Somil to run it into the end zone. So the answer is that the thing that we both firmly advocate getting rid of is this requirement that a civil rights plaintiff have to be able to identify a pre-existing case with functionally identical facts. There's no statutory basis for that. It doesn't make any sense from a policy standpoint. It is incredibly pernicious. So that's the thing that we get rid of. Now, interestingly enough, it is not the qualified immunity doctrine that imports a reasonableness standard into civil rights litigation. It doesn't. It literally is just about whether you can point to a pre-existing case on point. Reasonableness never comes into the analysis. The way reasonableness comes into the analysis, and it does in civil rights cases, is because most of the relevant constitutional provisions, including particularly excessive force claims and unreasonable search and seizure claims under the Fourth Amendment, build in the reasonableness inquiry. Why? Because the Fourth Amendment prevents unreasonable searches. It prevents or prohibits unreasonable seizures. So you will still have a reasonableness element if you get completely rid of qualified immunity, which both of us advocate, and it will be up to the government official, the police officer or whomever else, to explain to a jury why they believe that what they did under the circumstances was in fact reasonable, and then it will be a jury of their peers and the plaintiff's peers who will make the decision about whether under the totality of circumstances the conduct at issue was reasonable or not reasonable. We don't need qualified immunity to make that inquiry, and qualified immunity doesn't purport to include that inquiry. It's already built into most provisions in the Constitution that come up under Section 1983. Rather elegant, rather just.
Yep, couldn't agree more. In fact, I would argue that the Supreme Court has done a fantastic job of turning the Fourth Amendment into its own qualified immunity doctrine anyway, because the reasonableness standard under the Fourth Amendment is extremely hard to satisfy. Look no further than Graham v. Connor, which allows the government to argue from the standpoint of a reasonable officer making split-second decisions, not just a reasonable human being. So they've already built protection upon protection into the constitutional analysis. So again, I also agree that we don't need qualified immunity to protect against what police officers might say is an unfair standard against them. And I think I'm so glad that that this panel is not simply about qualified immunity, but tying it to the sort of nascent police reform conversation we're having. So let me say now, in line with what we're talking about, I think we also need to be very honest about what policing looks like today. Because I think qualified immunity, much of the support for it, or even the support for a very strict interpretation of the Fourth Amendment, is built on a sort of law and order conception. And by law and order, I don't mean the term of art, I mean the TV show. I think it's built on a misconception of what policing is like today. You've probably all seen statistics that less than 5% of all police time spent is spent investigating violent crime. Even a smaller percentage of that is spent in, let's say, an active shooter situation where a police officer would need to make a split-second decision whereby you might want to start thinking about protecting that split-second decision, right? I don't want to hand-wave those very significant moments in a police officer's life. They happen, but they are vanishingly small. And I think that the Constitution already protects those. But in the vast, almost to a rounding error, all police interactions with non-police human beings and often pets, there is no such split-second decision going on, and yet qualified immunity is just as strong in those circumstances as others. So when we talk about qualified immunity and whether it should go away, I think it goes hand in hand with the conversation about whether we truly need police doing most of what they do already. So I hope that we can eventually get to that point in the discussion where we can marry up the notion of police accountability and potentially shrinking the footprint of the police, both of which, eliminating qualified immunity and shrinking the footprint, both of which will do a lot to not only protect individual citizens, but also to, as Clark said, benefit law enforcement and stop infantilizing them.
Could I just follow up with a real world illustration of a point that Somil made? So I used to work for the Institute for Justice, and they actually had a qualified immunity cert petition in front of the Supreme Court this past term. It was a case called West v. City of Caldwell, and what it involved was a situation where police were in pursuit of a suspect, and it was actually somebody they were pursuing who was, skip bail. And so they asked the girlfriend of this individual, can we search your home because we think he might be in there? And she said, well, I'm pretty sure he's not, but yeah, go ahead. So what the police then did was, after several calls to the police department lawyer, trying to decide, hey, having gotten consent to search this person's home, does it seem like it would be okay to throw a bunch of incendiary devices into the home, nearly burn it to the ground, and perform one of these, what SWAT teams refer to euphemistically as a dynamic entry? And that's exactly what they did. They nearly killed her dog. They nearly burned her home to the ground. They destroyed most of the interior by throwing in flashbang grenades after talking to their own lawyer several times. Give me a break, split-second decision-making in the field. I'm not saying it never happens, but I agree with Somil that that part of qualified immunity is vastly, overblown. And nevertheless, when they were sued by the woman whose home was effectively destroyed by their dynamic entry, they raised qualified immunity and said, hey, we should be immune from being sued. Because why? Because she gave us consent. How many people really think that consenting to a search of your home would entail nearly burning it to the ground by throwing a bunch of incendiary devices into it? I suspect very few, but that's their position, is that once we got consent, essentially we could do anything to that home that we felt like, and it would not be fair to hold us liable for virtually burning our home to the ground after we consulted with our lawyer several times. So there are abundant real-world examples that demonstrate that qualified immunity absolutely is not limited to these genuinely split-second decisions that police sometimes have to make in the field. To the contrary.
And let me just say that example makes clear the perverse incentives that qualified immunity makes. It essentially says the crazier you act, the less clearly established it is. And that is crystal clear.
Yeah, so thanks. Y'all are doing a great job. I really appreciate it. I just have a quick question for you all. So, I lost it for a second. Give me 1 second. Yeah, so state legislatures are looking at ways to end immunity for state officials. Where is this question? Oh, here it is. Okay, excuse me. So while courts continue to address qualified immunity, state legislatures have contemplated ending state official immunity. For example, Colorado enacted a ban on immunity this past summer, and the Virginia House of Delegates is considering similar legislation. Is state action enough, or does qualified immunity ultimately need to be addressed by Congress or the Supreme Court?
So I'll start quickly, which is while I commend states for attempting to limit qualified immunity as to their own state civil rights statutes, I don't believe, and I'm worried that Dean Farnsworth is going to call me on this, but I don't believe that that's going to be enough for folks wanting to bring federal civil rights actions under Section 1983. I think we've got to get the federal Congress and or the Supreme Court on this issue. That said, I think states can be creative about other forms of police and official accountability, certainly. They can create civilian oversight boards. They can create requirements for their insurance providers to make sure that they can't provide insurance to police departments or individuals who have a history of misconduct, right? We can certainly be creative at the state level. But if we're talking about qualified immunity, the federally created judicial doctrine, I think we need a federally created solution. But Clark or others, let me know.
I agree with that. I certainly applaud states that are eliminating qualified immunity for state civil rights actions. My colleague Jay Schweikert, who is also from the Dallas area, perhaps not coincidentally, was actually asked to testify in connection with the Colorado statute that you mentioned that was ultimately passed and expressly declined to include qualified immunity. But let me ask you this. Does anybody know how you get on the Court of Appeals in Texas or the Texas Supreme Court? Does anybody know how that happens? You get appointed by the governor. That's how you get on that court. Do you think a trial court judge who has been unduly friendly or was perceived to have been unduly friendly to civil rights plaintiffs and cost the state a lot of money in civil rights cases is more or less likely to get the nod from at least some governors in the state? And I'm not saying it's all politics. I'm not saying that, you know, being fiercely protective of people's civil rights as a state court judge would be disqualifying. But I am saying that I think that a trial court judge in the state of Texas who was interested in being promoted to a higher court would have that very much in mind, and much more so than a lifetime appointed federal judge.
So this actually comes, I'm glad that we brought up kind of the need for congressional action. We actually have a question from someone kind of around this issue regarding the issue of congressional inaction. And what they ask is, doesn't congressional inaction over 2 generations amount to acquiescence and acceptance of the doctrine? And so kind of what are your thoughts on this? And kind of, you know, would Congress need to get involved? Do you see the Supreme Court ever taking this on, any of the appellate cases that are in the pipeline? So kind of what are your thoughts on this?
So the good news about qualified immunity, if you hate it as much as some of you do, and you should, is that there are actually multiple paths to, to a better place. We've already talked about one of them, which is states enacting state level kind of, Section 1983 analogs that would perhaps fill in some of the gaps. But I agree with Somil, would not be sufficient by themselves. At the federal level, because qualified immunity purports to be an interpretation of a congressionally enacted statute, Congress does have the power to pass a law to amend Section 1983 to clarify that qualified immunity is not a defense that's available under that statute. My colleagues at CATO and I, along with others, and our friends at the ACLU have been active in trying to educate legislators about the importance of repealing this qualified immunity doctrine legislatively. There's been some very strong expressions of interest among certain members of Congress, including some, sort of what you might think of as law and order Republicans, but there have also been some obstacles. So that path remains open. On the other, the other branch of sort of the federal path is the judiciary, and it's the Supreme Court reconsidering qualified immunity. We had a very disappointing experience this spring in May, where the Supreme Court held about 8 or 12, depending on how you count, qualified immunity cert petitions, for some of which have been ripe for over a year. I've never seen anything like that in my 25 years of litigation. It was very unusual. Clearly, the qualified immunity issue was on their radar screen. And then, it seems like at the last minute, for whatever reason, the court just blinked and decided, you know what, we're not going to hear any of these cases. I do not believe that so-called congressional acquiescence with the qualified immunity doctrine necessarily represents, a certain. One should not draw a conclusion that Congress, therefore, should be deferred to, or like their inaction means that we shouldn't get rid of qualified immunity, for a couple of reasons. First of all, there are some very strong public choice dynamics that's at work here. The law enforcement lobby is probably the second or third strongest in the United States. The Department of Justice actually has an entire department called the Office of Legislative Affairs that is an in-house lobbying shop. And there's probably no issue that the law enforcement community cares more about than maintaining what I call our near zero accountability policy for law enforcement. I'll say it again. The law enforcement community probably has no higher priority than maintaining near zero accountability for law enforcement. They exercise tremendous political power on Capitol Hill. And, I don't want to throw stones exactly, but you can imagine that there's something fairly attractive to a legislative body about being able to say to their law enforcement constituents, hey, you're welcome for not getting rid of this doctrine that shields you from liability for your own misconduct, while at the same time being able to say to the general public, hey, that wasn't us. That was the Supreme Court purporting to interpret a statute that we wrote that was actually different from the way that it's been interpreted by the Supreme Court. So Congress kind of gets to have its cake and eat it too, and present different faces to different constituencies. So at the end of the day, I think it's still, both paths are open. Congress might reform it. The Supreme Court might eliminate it. One way or the other, I do think that qualified immunity has to go because it's just doing tremendous damage to the very institution of law enforcement. We'll get into that more, I'm sure, in just a little bit. We've alluded to it before. But I really think that one of the most powerful drivers of frustration that we see spilling out into the streets over the last few months is the recognition of so many people, so many members of the general public now recognize that one of the key things about our criminal justice system is that members of law enforcement hold us to an incredibly high standard of accountability. You can actually be prosecuted, convicted, and incarcerated for engaging in conduct that you didn't even know was illegal. But when the shoe is on the other foot, and the question is how much accountability law enforcement should be held to, they demand an extraordinarily low level of accountability. So here we are way up here, and here's law enforcement way down here. And people are finally realizing that's the way it works in our system. And guess what? They're angry about it, and they should be angry about it.
Yeah, and I mean, I second every word of that. And I'll say that in terms of, you know, if we're reading tea leaves here, I would not read the Supreme Court's declination of cert as a disinclination to address the question. I actually think we were slightly victims of our own success in that the question was up at the exact same time that people were marching in the streets in the wake of the death of George Floyd. And as we all know, the Supreme Court enjoys lagging public opinion. They don't like leading it, right? And so while we had built this drumbeat so loud that folks were marching in the street and using the term qualified immunity as one of the things they wanted out of the accountability movement, I think it's possible that the Supreme Court said, well, we don't have to take this on right now because it looks like there's going to be movement elsewhere, right? Now, that hasn't happened yet, and I'm disappointed they punted, but I don't think they punted because they just don't care about this issue or that they think qualified immunity is necessarily right. If you just count up the votes, I mean, we've got them. Read a Clarence Thomas dissent about qualified immunity, and you'll know that the numbers are not the issue. I think it's more that the Supreme Court enjoys lagging public opinion, and we're cresting right now, so perhaps they'll never have to wade into this thicket, and we'll just pass it as a congressional piece of legislation. And I still think, as Clark said, we could do it either way in the next couple of years. So while Baxter and, you know, the cases that didn't get taken up were a huge blow, I'm not down at all. I just think we have to wait a year.
Cool. Well, I really want to move us on to a kind of a broader conversation about police reform. Before we do, I want to hit like one rapid fire question for the court watchers among us. Are there any mulligans, any second chances coming up to the appellate courts, cases that we should be paying attention to?
Well, the news here is very good because our friends in law enforcement provide us with a never-ending source of ideal qualified immunity vehicles. And yes, there are a number that are working their way up through the courts. One that I have my eye on, Somil, do you know whether the Fifth Circuit, Taylor out of the Fifth Circuit is ripe yet? I can't remember.
No, I don't think so.
Yeah, so this case will blow your mind.
Oh, the chat says there's one in long conference right now, but in any case, go ahead, Clark.
Yeah, so this is a case out of the Fifth Circuit where what happened was that the plaintiff was held in jail, meaning he was arrested and being held pre-trial. And the conditions that he alleges he was held in, and we have to accept his version of the facts at this stage in the litigation, are astonishing. In essence, what he says was that he was held in a very cold jail cell that used to be used by a mental health facility and was caked with human feces on every flat surface, every wall, floor, ceiling. And not only that, there was no bed and no mattress, and the drain was backed up so that effectively he was standing ankle deep in an open sewer, and they held him in these conditions for 6 days. And guess what? The Fifth Circuit granted qualified immunity. Why? Well, we just don't happen to have a case where somebody's been held in an open sewer for 6 days pre-trial. So how would the people running that jail know that you're not supposed to do that to a human being? Now, keep in mind, if you did that for even 1 day to your pet dog, you would be prosecuted for felony abuse of an animal. But when a bunch of jailers do it to a human being, the Fifth Circuit says, well, I mean, how would they know not to do that? Better let them off the hook. That's just one example of the kind of case that remains in the pipeline for qualified immunity getting to the U.S. Supreme Court.
And I'll just follow up and say, while I don't know of a case that's up right now, Clark, you might, or others in the chat might, I think the next interesting question is going to be around the obviousness prong of qualified immunity, which we haven't touched on yet, and I know we want to move on, but just, Hope v. Pelzer established that there is some level of police and official misconduct that is so obviously unconstitutional that we can bypass the clearly established prong. In practice, that never happens. And so for the court watchers, if you can find a great case teeing up the Hope v. Pelzer exception or prong or whatever you want to call it, please call us because we want to litigate that too.
Cool. Okay. Thank you for indulging the brief aside there. Now let's kind of move back to what we have been talking about. And I think both of y'all have said this pretty well. There's been like a realization about the nature of policing in the United States that has sparked outrage. As y'all know, over the last couple of months, the mantra of defund the police has become kind of a rallying cry. And so we just want to know, how does this conversation that we're having fit into this larger conversation that people are having about police reform? Where do we go from here?
So I'll start, since I would be likely tagged with the defund police moniker. I think, as I alluded to earlier, I think it's vitally important to have these conversations about accountability and right sizing at the same time. So to be clear, I think qualified immunity should be abolished no matter what we do to the size of police in any given community, right? It's wrong as a matter of law, and therefore we can address it on its own terms. But we have to also see it in context of what we want policing to be, right? And so, as I mentioned earlier, eliminating qualified immunity allows folks to achieve a higher measure of justice when they are wronged by the police, right? But the reason, as Clark said, we have a never-ending flood of qualified immunity cases wending their way through the courts is because the police are interacting with individuals far too much. And I think, as we've mentioned earlier, everyone would agree with that, including police. Police do not want to be responding to loud campus parties. They don't want to be responding to mental health crises, right? They say that. Police, in poll after poll, say two things consistently. One, we want to eliminate the bad apples. We want accountability because the rest of us want to build back the community trust required to do our jobs properly. And two, we want to stop doing this penny ante stuff so that we can do the jobs that we signed up to do. Now, we can have a conversation about whether they even need to do those jobs and whether they're doing them right. But even taking it from the police's point of view, I think most police deep down, and if they're not caught in the political crosshairs that we're in right now, will say, I want to do less of the job I currently do and more of the job that I signed up to do. And so, and like I said, I want accountability for the other guys who do it poorly so that I can be viewed as the community servant that I believe that I am, right? And so that's where qualified immunity and what I tend to call right-sizing the police overlap. So I would love to see a movement going forward that says, let's take 30, 50, 80% of what police are currently forced to do, give it to community partners who are better trained to deal with things like mental health crises and substance abuse. Take the remaining percentage of police and then excise from that those who are consistently violating constitutional rights and not being held accountable, aka get rid of qualified immunity. And then we might arrive at a consensus position, maybe not consensus, but more of a consensus as to a subset of police that we might truly need and who are truly doing the job that they want to do. So that's how I see them interacting.
I'd like to give you the following image, and I hope it works. Imagine that you're trying to have a really deep and important conversation with a good friend of yours or a member of your family about a really important and difficult subject. And every 5 or 10 seconds, somebody just comes along with like a boat horn and just goes, "Bah!" Right? It's going to be very difficult to understand what that person is trying to say to you. And I think that qualified, in my illustration, the Supreme Court is the person with the boat horn and qualified immunity is the boat horn. And here's what I mean by that. We as a society have to be able to provide feedback to government officials, including particularly police officers, about what we expect from them in the way they do their job. When should they be using lethal force? How much should they hesitate to make sure before they start shooting? When is it okay to use certain kinds of law enforcement techniques, like a chokehold or kneeling on somebody's neck, and so forth? And the problem, one of the biggest problems with qualified immunity is that it is interdicting the channel of communication that our society depends on for people to send information up the chain to the government. And that's the jury trials that are supposed to occur when those kinds of incidents happen, but are not occurring because qualified immunity steps in and throws out the case. Let me give you another real world example. This is another one of the cases that was in which cert was denied by the Supreme Court back in May. This is a case at a public swimming pool in Nebraska where a woman was at the pool with her boyfriend and her 2 daughters. They were horsing around in the pool. Somebody misinterpreted what was going on and called the police. The police show up and they ask the woman and her boyfriend to step out of the pool, and they question them separately. And during the questioning, keep in mind, the woman is about 5 feet tall. She's wearing nothing but a bikini, and she is not armed. She is also, under the circumstances, understood to be the purported victim. She has explained to the police officer that it's a misunderstanding and there's no problem and she wasn't in any danger. While this is going on, she looks over and sees that one of the other patrons at the pool is essentially provoking her daughter. And she says to the police officer, "Hey, I need to go and deal with this situation with my daughter, excuse me." And he says, "No, you will stay here and talk to me." And she says, "I will talk to you, but I need to go help my daughter right now." She turns and begins walking away from him. He comes up behind her, lifts her up in a bear hug as high as he can, turns her upside down and drops her on her head as hard as he can, knocking her unconscious and breaking her shoulder. And the Eighth Circuit, en banc, 8-4, granted qualified immunity because why? Again, apparently if you're a police officer, you just wouldn't know to pick up a petite, unarmed woman who you believe to be the victim of a crime and pile drive her on her head simply because she told you she needed to go and take care of one of her children during an interview. That is what I mean, and that's what Somil and I both mean when we talk about the way that qualified immunity infantilizes law enforcement. But it doesn't just infantilize law enforcement, it deprives them of valuable information about what the rest of us expect from them when it comes to the way that they do their job. A jury in Nebraska should have had the opportunity to send that information to the police officers involved in this incident, and they do not get that chance. Why? Because the Eighth Circuit faithfully applied the judicially invented doctrine of qualified immunity, and every one of those police officers involved in that incident, I guarantee you, looked to the judiciary, and what did they see? A big, bright green light. That's what they saw.
Thank you so much for that. So I think we have like 2 more questions. So I think Anthony has, I think, one from an audience member, kind of tying into what we were just discussing.
Yeah, so Mr. Graham Rex is concerned about how qualified immunity will impact the crime rate. So he's wondering if with these proposed solutions, these proposed reforms make policing harder, and would crime increase from defunding the police? That is seems to be his concern. And I think a lot of people on the right might have those concerns. So if you could touch on that for a second.
Clark, you want to take it first?
Yeah, I'm going to go real short because I think you probably have more interesting things to say than I do. Let me say this. I am really just sick and tired of hearing about how people will not want to be police officers if they're held accountable for their misconduct the way that doctors, lawyers, and other professionals are. I started off my career as a young lawyer doing a lot of medical malpractice defense cases. My sister's a doctor. I'm sure there are plenty of doctors who would like to have something like the qualified immunity standard because they make a lot of difficult decisions under conditions of risk and uncertainty, but they don't get qualified immunity. They have got to meet the basic professional standard of their profession and make good decisions even under conditions of uncertainty and risk. And it is appalling to me that people suppose that somehow police won't want to go into the profession if they're held to the same standard of accountability as everybody else. We can only predict. My guess is this: what will happen if you get rid of qualified immunity is that some of the worst police officers who know that they will be exposed to liability because they make bad decisions in the field that they will not be able to explain to a jury, they'll be the ones who quit the professions. And to that I say, great.
So I agree with that position on the qualified immunity piece. And Anthony, I think at the end, we sort of conflated in a good way. We also brought in defunding the police or reallocating resources from the police. And to that I say, look, I want to be as sympathetic as I can to people's concerns about their own safety. That is a human need for safety. And what I don't want to concede is that police are the only way to get there. And I think that's where we have a disconnect in the current discourse. Right, left, it doesn't matter. I think because we've only done it one way, we are terrified of trying it another way. But I want to say, without disparaging police in any way in this manner, police haven't proven so great at solving crime themselves. And certainly the criminal justice system as currently constituted, whereby we arrest people after the fact and then prosecute them and send them to jail for a long time, certainly has not solved any of the societal ills that we're purporting to solve via the criminal justice system. In fact, there's more and more research that the longer we send people to prison, the more criminogenic it becomes, aka we send people out with fewer and fewer resources and more problems, and so they might go out and commit what we call crime again. And so I think while it is always difficult to move on from the status quo, especially when you feel something like your safety at risk, I think if we look at it objectively, it is time to try something new. And folks across the ideological spectrum have put forward very concrete solutions to how, if we were to right-size the police, what we would replace it with, right? Violence interruption programs, public health officials, mental health experts, substance abuse experts, right? Let's look at the case of Jacob Blake. Jacob Blake was doing what we would want community members to do. He was helping break up a fight in his own community without violence, right? We should actually commend that conduct. But instead, the only solution we currently have was to send a police officer out there, and we all know what happened, right? So again, I want to be extremely sympathetic to folks concerned about public safety, and I want them to then look into alternatives that might actually guarantee public safety in a better way than what we've done so far, because right now we're getting zero return on our investment.
So one of the things that's kind of interesting about kind of the doctrine of qualified immunity is that this is a civil means of getting liability and holding law enforcement accountable. And as qualified immunity has kind of risen in public awareness, one of the even I think bigger calls this summer and really at large is the calls to arrest and prosecute police officers who shoot and kill unarmed civilians, who shoot and kill protesters, and that functions within our criminal system. And additionally, you also have kind of the administrative accountability through kind of administrative leave, firing, things like that. And that often is influenced by police unions, which I think Clark had alluded to earlier, have a huge political influence over the way that we hold law enforcement accountable. So I was wondering if you both could kind of touch on how these two interact, kind of if maybe as we're talking about qualified immunity, we also need to maybe start looking at prosecution, the role of police unions, kind of this broader way of holding law enforcement accountable.
Yeah, I'll start quickly, which is to say, yes, all options need to be on the table. This is a societal, systemic problem. Qualified immunity, we think, is a big part of the solution. No one's saying it's a panacea, right? I'll address specifically the prosecution piece. I think, while, again, I'll be sympathetic to people's calls, especially in light of the very obvious two-tiered nature of our criminal justice system, that when they see particularly marginalized folks being prosecuted so harshly by the system, that when police do the same thing, they want that same level of accountability, right? I get that gut feeling. at a philosophical level, I don't think we want to start curing the criminal justice system with the criminal justice system. That's a sort of personal, deeply felt skepticism of the criminal justice system, period. I would like for us to think of more creative solutions to societal problems than simply jailing them. But even if you do believe that some level of prosecution is necessary, and I see where you're coming from if you believe that, I'm pretty sure it can't be done via prosecutors who have an inherent conflict of interest with the police that they work with every day. So I think there at least needs to be a level of removal or several levels of removal from the DAs who work with those same cops. We can't possibly expect them to then prosecute those cops with any modicum of objectivity. So I think if you're going to go down the prosecution route, you need to think of very airtight independence mechanisms to go along with it.
Cool. Clark, would you like to jump in on that too, or?
Yeah, I think it's incredibly important to understand that anytime somebody suggests to you that there is some other avenue of accountability besides the ability to file a civil rights case against a police officer, man, you better put your hand on your wallet. Criminal prosecution is not an effective means of accountability. First, because not all police misconduct is criminal. And second, because the decision whether to prosecute a given alleged crime by a police officer has to be made by a prosecutor. They have a massive conflict of interest. They work with police. They depend on police to bring them cases. They depend on police to testify in their cases. Talk to anybody you know who's a prosecutor and ask them, if you know them well enough to get a candid answer, whether they feel comfortable getting a reputation as a prosecutor in their office who's likely to bring charges against police. And I guarantee you they'll say no. That is a ticket to a very short and very unpleasant career as a prosecutor. I would guess that probably there were about 270 people struck by lightning last year in the United States. I would guess that's probably more people than prosecutions of police officers, at least for major crimes. It's not an effective means. And police know that they're unlikely to be prosecuted, so it's not going to affect their behavior significantly. And if anything, internal accountability mechanisms are even more laughable. Because why? Because you're asking the police to decide whether the police did anything wrong. If you want a really horrifying statistic, go and look at the number of complaints against police officers that were sustained by the city of Chicago over the last few years. I think you can count on the fingers of one hand the number of complaints that have been sustained against Chicago police officers, and I can assure you that is less than the number of times that police officers have engaged in misconduct in Chicago. So the only real viable avenue for accountability for police in this country is the ability of an individual citizen to bring a civil rights case unilaterally on their own without having to persuade some government official to proceed against the police, because good luck with that.
And I'll jump in just to manufacture some drama between us. I'll say that long-term, even qualified immunity may not do this, and I know what I'm about to say might come off as pie in the sky, but until we fix the culture of policing and prosecution, and until we right-size the function and stop making it such a pervasive part of our society, which will take a lot of effort and a lot of soul-searching, none of these solutions are going to be 100% effective.
That's right.
Cool. Okay, we have a series of questions, and I recognize that we are at time, so if anybody needs to hop off, totally understandable. But we have a series of questions that I think I can kind of all tie into some work that Clark has done, so you'll have to indulge me for a second. But one question coming in from Hannah Schiffman. She says, in Texas, there is the analogous med-mal reform, which protects doctors, and we have plenty of doctors, but police aren't risking their own money. Most police departments or jurisdictions just foot the bill. So will the deterrent of liability be effective if cities and unions still protect bad actors who do not see the consequences for their actions? And then another one of our FedSoc officers, Tanner Baird, asked, would Clark discuss his idea about police departments buying liability insurance for their officers? And I think that those two things go quite well together.
Yeah, I agree, and I really appreciate those questions. So let me say up front, one of the biggest fallacies that you can commit in public policy is to suppose that when you change one thing, everything else will stay the same, because usually that is not the case. If we eliminate qualified immunity, there will be, I believe, a significant uptick in the amount of litigation that occurs. talk to any civil rights plaintiff's attorney, and they'll tell you that a significant part of their decision about whether to take on a given representation is whether or not they think they can surmount qualified immunity. So to a pretty high degree of certainty, we'll see more litigation and more payouts, because cases in which police have engaged in misconduct that now get dismissed will not get dismissed, and so they'll either be settled or resolved otherwise in favor of the plaintiffs. And currently what happens in Texas, but also across the country, is that almost without exception, it's not the police officer who engaged in the misconduct that has to pay the damages. 99.98% of all civil rights dollars paid out in America are paid not by the officer who committed the misconduct, but by the department or the municipality, which ultimately means by us, the taxpayers. Because why? Because they negotiate, they being the police and police unions, negotiate these indemnification agreements with their employers. And so they're never on the hook, we're on the hook. I think that something that's very likely to change if we get rid of qualified immunity is this indemnification regime where we, the taxpayers, end up covering virtually all of the damages for police misconduct. And a proposal that I and others have made, and it's interesting because I know this proposal has been made by several people independently, is to simply require police officers to carry professional liability insurance just the way that doctors, lawyers, and other professionals do. And if you actually look at the numbers, it's remarkable how inexpensive professional liability insurance would be for police officers, because it is actually true that the vast majority of misconduct is committed by a relatively small number of officers. So the officers that don't engage in misconduct, that don't generate significant amounts of claims, the price of their liability insurance is going to be quite modest. And we could even have a system whereby the department provides them with a subsidy to go out and purchase liability insurance, so it could even be no money out of their pocket. And one of the beautiful things that would then happen is you would bring the actuarial power of insurance companies to bear on the problem of police misconduct. The insurance company would have an extremely strong motive to identify officers early in their career who are either not cut out for the work or who need additional training in order to be better police officers that are more respectful of people's rights. And as somebody who has both represented insurance companies in frontline litigation and also in what's called insurance defense cases, I can tell you that for all of their other sins, insurance companies are extraordinarily adept at identifying risk and mitigating risk. And it's tragic to me, particularly as a libertarian who supports, free market principles, that we are leaving the power that insurance companies have to help identify risk in this setting, the setting of police misconduct. We are literally just leaving that right there in the field, this low-hanging fruit that we could be employing to have better police departments, better police officers, and less misconduct. And there's no jurisdiction that I'm aware of that employs this incredibly powerful tool that the market has to offer in any significant way. And you know what? It would literally just be a matter of changing policy at the municipal and or the state level. And we could have a complete transformation of police culture tomorrow if we chose.
So we are a little bit over time, so I do want to wrap up. Thank you both so much, and thank you everyone for who attended. We really appreciate it. Just kind of as a wrap up, we've talked a lot about policy and kind of doctrinal changes. Many of the people in this audience we are going to be joining the field. We'll be members of the legal profession too. So what can we do as law students in addressing the culture and issue and kind of around this issue, from qualified immunity specifically all the way to this broader issue of our culture of policing?
Well, I'll start, and I'll pick up on my point about changing culture. I think you'll join the profession soon enough. You'll learn the legal tools required, or you can maybe audit our public interest litigation class over at George Mason. But I have no doubt that you'll all be adept litigators, and some of you will use that adeptness to fix qualified immunity and other problems with the law enforcement system as we know it today. But what I think lawyers don't do enough of, and we can all learn to do more of, is get our hands dirty in the streets and organize and to change culture in real time, right? We often put ourselves in an ivory tower or a burnt orange tower, whatever is your fancy, and we fail to recognize that this change happens on the ground faster than it does in courts, faster than it does in op-eds. faster than it does in state legislatures. That all happens when there is a groundswell coming from you. So take your free time and go learn the nearest grassroots organization that is advocating on behalf of defendants, advocating on behalf of the incarcerated, the downtrodden, the poor. Figure out where they're at and lead them to this realization that you have and that you're lucky enough to get being at a place like UT. And that, I think, will move the ball much farther than any one lawsuit can.
So I have what might sound like a somewhat contradictory. It's not contradictory, but it's a somewhat different perspective. My number one suggestion that I would make is make yourself excellent. Advocacy is difficult. Legal writing is hard. It takes experience to learn how to do. And the legal culture has changed in such a way that, you know, you talk to sort of older lawyers, they spent more time in a courtroom than you're likely to spend in a courtroom. Where most legal advocacy happens is in writing. You have got to make yourself excellent on paper. And just learn all the skills of being an excellent advocate. One image I might share with you would be like, you're in law school and it's almost as if you're growing these Wolverine, claws. And it's not to say you can't go out and get involved. It's not to say that you should just, do nothing but study and be a lawyer. But my suggestion would be, don't be impatient. Grow those Wolverine claws out so that when you go out and you take on the system and when you take on injustice, you are the best advocate that you can be, because that's what changes the law is somebody who brings the skills of an advocate to a situation desperately in need of change and makes an argument that is powerful enough to change the status quo. Each and every one of you have the ability to do that. You're at one of the best law schools in the country if you're at the University of Texas. So stay passionate, but also stay focused on your training as a lawyer so that when you come out, you know how to use that, and I'm going to mix a metaphor here, that lightsaber that will be handed to you the day that you're admitted to the bar. Go out and be excellent. Be an excellent advocate, be an ethical advocate, and you will change society.
Thank you both so much. And again, thank you, Dean Farnsworth, for kind of being here, Seth and the Federalist Society, Anthony, and Southwest Black Law Students Association. And for those of you who couldn't hear, so behind the scenes is the ACS events director, Ria Shahane, who was like instrumental in doing this. This event would not have happened without her. So Ria, thank you. We really appreciate it. You have worked your butt off and you did a great job. So thank you.
Great job, everybody. Thanks to our panelists and to our wonderful student leadership of these great groups for putting on a wonderful night of really interesting discussion. Well done all the way around.
Thank you very much. I had a great time. We'll come back anytime.
All right.
Thanks to all of you. Wonderful
Thank
experience. Thank you.